Hello. Oh my gosh, as the day is wearing on, I'm getting wilder and wilder. Like looking at going, oh my gosh, up and down the stairs like 150 times. This is our chapter overviews. I'm looking at chapter 3 and then pages 255 through 262 and then chapter 13. This is part of the homework for our week 3 stuff. So this will be in our week 3 learning plan. It starts with chapter 3, the safe employment decision. Make sure that you take some time to look through this, partly because not just what you cannot do and what you can't do, is it gives us a lot of really good verbiage to be familiar with. So in the first page here on 53 that starts the chapter, you must exercise sound business judgment and base your decisions on a bona fide occupational qualification or some other valid business reason. So for you to do that, you really have to have some information, right? So if you turn the page to 54, like understanding what subjective hiring criteria is. It should not be subjective. I mean, there are subjective things like working well in a team, but we can ask really good questions that are behavioral and situational in nature to try to make it much more objective, and then adding rankings, that sort of thing. It's hard to measure soft skills, isn't it? But we can do better. Don't ask if you're a people person. Oh my gosh. On page 53, that's where all this testing comes in. We're always looking for some magical bullet, right? Some test that's going to give us the perfect candidate. Believe me, I have done so much corporate training over the years, and in this area, I always have people saying, Rox, oh my gosh, why does my best interviewee turn out to be my worst employee? The nightmare employee, right? Well, because you can pass tests quite easily if you know what they're looking for. So integrity tests, personality tests, these kinds of things, be very, very careful about this. My advice is to just never do it. Like, for example, Myers-Briggs. Everybody loves Myers-Briggs. There's absolutely no science behind it. Read Annie Murphy Paul's book called The Cult of Personality Testing, and there's a really long subtitle to that, and you'll understand why I feel that way. And we do have cases on file, if you read her book, that show that those people that have tried to use those tests for making workplace decisions were found guilty. Okay. California Supreme Court, one case comes to mind there. They were using it to decide things like even custody of children and benefits and things like that. It does not show anything like that in the least. Now, where testing becomes more important is for something that's actually related to the job. Like we talked about math skills before, or if you have to carry heavy things or whatever, I can test you for that. Okay. Hiring by committee. There's a case on page 66 and 67. Review that. That gives you a really good example of, kind of the ins and the outs and the ups and the downs of using a committee for hire. Proactive action. On page 57, they use the 3-point test, and I think this is really wise. Test 1 is a given criterion, a requirement for the productive, proper, and safe performance of the job. Test number 2, are criteria even-handedly applied? And test 3, has every reasonable effort been made to recruit or to accommodate members of protected classes? If whatever it is you're doing can provide or meet the 3-point test, all 3, then you're probably pretty safe. I'm not going to say anything's a sure game, right? Affirmative action, you can read a little bit about that. We don't require affirmative action unless you have government contracts or some other criteria, but you can read that here. In my day, affirmative action was coming into its own, but it was even then, I'm talking late 70s and the early 80s. There was a purpose for it and why we had started doing it through the 60s and the 70s and all of that. But even then, we were starting to question its usefulness. So, and then the rest of the chapter is the case books, the case study. Does an older employee have to accept your offer? I think we're actually going to read that case or use it for something, and the one on 61 as well. But make sure you read through the cases, because they're often the best way to describe even those little snippets, a few pages of the chapter, and why you see so many cases, because they help actually illustrate what it is they're talking about. And that's why we'll be referring to these on and off throughout the coursework. Now, if we go to page 255, this is that section 3, safe firing practices. Remember that the at will, everybody knows, oh, this is an employment at will. I can fire you whenever I want. That's a labor management philosophy. That is not law. Okay, be very careful about that. And I like that they understand and make that clear here on 255. Employment at will presumes that employers hire and fire people for and at their own convenience. The theory right, theory allows employers, in the absence of a written agreement, to hire someone for an unspecified period of time and fire him or her with or without cause, with or without notice. In short, to employ and terminate at will, right? Of course, the philosophy assumes philosophy, right? Words like theory, philosophy, doctrine are not laws. Of course, the philosophy assumes that the employee has the equal right of quitting at any time, with or without cause, with or without notice. But it notes here, times are a-changing, and this was way back in 2004. Through contract law and public policy, employment at will being the only basis for a firing can easily be drawn out in the courtroom. Okay. So again, definitions help us understand some of this a little better. So if you go to page 256, definitions of key terms, what it is to mean, what is a contract? What is an explicit contract? A bilateral versus a unilateral. Bilateral, meaning a contract agreed upon between two people. Unilateral, this is interesting because an agreement which only one party offers something of value. The other party may not even know that the contract exists or that the offer has been made. So, for example, they give us here, if you made a specific promise, even orally, an offer, when someone accepts a position, that offer can, in some states, bind you. Okay, that's why we also say that we often say that in contract law, verbal contracts is valid as a written contract. That could be argued both ways. It's legal stuff. Can always be argued both ways. But keep that in mind. So promising not to fire someone unless he or she screws up badly, quote unquote, because that's in one of the cases that you'll read about, you'll find out that that's not going to hold water. You just violated a unilateral contract. Implied or implicit contracts, you can read this. Not that we're going to get into all kinds of contract law, but a hiring agreement is contract law. That's kind of where it falls under. And sometimes people sue for the wrong things. Sometimes people sue because they feel like they were treated unfairly, and it gets along those lines of harassment or discrimination and those kinds of things. And often those are hard to prove. But if you can nail it down that they violated contract law, now you might actually be able to win your case. Now, on page 257, good faith, fair dealing. Whew, does that ever sound fuzzy, right? Talk about soft language. The doctrine imposes contractual constraints on promises made in employment relations by recognizing the importance of trust in negotiated agreements. Okay, that's why it's important that you remember this, that a good faith or good, fair dealings, that's why the judge asks things like, what was your intent? Malicious, or was it in good faith, right? On 257, it also makes, I also noted in my notes, making exaggerated claims and promises when recruiting employees and the failure to follow internal grievance procedures, to employ reasonable appraisal procedures, or to keep explicit promises prior to terminating someone, et cetera, et cetera. And you can see, you can look up the notes there. It's noted here, or the notations are here. But there's an article that I had, oh, it's a little bit older article, so I probably ditched it. It was out of the Wall Street Journal. And this is when the dot-commers, it's probably in the early aughts, 2000 something. The dot-commers, this really came up because, man, when the whole dot-com thing, Silicon Valley was really coming into its own, a lot of promises were made about making a lot of money, right? So they'd get, I mean, these workers were working 60, 80 hours a week with next to no pay or no pay, right? And then when it came time for them to, like, okay, I need some money, I need to get paid. Well, we're not there yet. They were starting to have big trouble with that. And then the companies got into more hot water because they were listing them as contract workers and not as employees. Another whole story. But so make sure it's in good faith or fair dealings. Outrageous conduct, you can read that. It's pretty much what it says. Disclaimers on page 258. This is interesting in that if you read it, an explicit statement declaring employment at will as company policy. This statement usually safeguards the employer's position. A well-written disclaimer, which they provide in this chapter, and later in the chapter there's some examples, in chapter 13, can prevent an employee handbook from creating an implicit contract. So disclaimers aren't necessarily going to protect you in the way you might think. It might protect you, though, from your hiring agreement being considered an implicit contract. Now, constructive discharge. If you think about, fast forward to where we are today, we know more and more about bullying in the workplace, which most likely would be filed under like a hostile work environment. So if you read constructive discharge, the type of wrongful discharge exemplified when an employer intentionally or unintentionally creates and allows conditions to creates and allows or allows, right? So that's where you may not know exactly what's happening, but you're letting it go on. Conditions to exist that lead an employee to believe he or she has only two options. One, to accept a personally adverse situation, or two, to actually resign. And this comes up over and over and over when we talk about bullying in the workplace, and emotional abuse in the workplace. Actually, Wisconsin's original law, I think, was called emotional abuse. Was actually the law where Wisconsin was one of the very first states to actually have something on the books in regards to bullying. Most states, even today, still don't. And then waivers, you can read that. We've talked a little bit about waivers in the past. Arbitration, I think most people can understand arbitration, and you can read that, and they reference the Arbitration Act of 1925, blah, blah, blah. Separation agreements, pretty simple. A document that identifies the employee's last day of employment, includes provisions for, the unused vacation pay. So we're all on the same page. Basically, a separation agreement should be just that, an agreement between both parties that we're on the same page of what I still have coming when I leave here and when I'm going to get it, right? The service letter. Now, this is really interesting too, because if you see how they noted here, this can be a little bit of a trap. So you have to be careful. The last part of it notes, make sure the letter states only the facts and states them in a manner that cannot be construed as a deliberate or malicious attempt to prevent the ex-employee from future employment. That's disparage treatment or adverse impact, okay? That's why documentation. Should I say it again? I can't remember how many times I've said it already. And then a letter of understanding, of course, that kind of is what it says. And then I think chapter 13, safe discipline and firing practices. This kind of just leads us right into this chapter as well. Wrongful discharge. There wasn't too much in here that you would really need anything from me. Discriminatory discipline. That's where be very careful about those policies and procedures that you have in your handbooks, right? You want to make sure it's not discriminatory and how it's handed out, right? Back to page 263, I do have a notation here. Workers defend themselves in court against breach of contract or wrongful discharge more frequently than before. This is very true. We're all very educated. I can go online. I can go on the EEOC and file it online. It's not so hard to do anymore, and we have a much more educated workforce because of the internet and technology. So if you think you can get away with just about anything anymore, like maybe in the old days, maybe not so much. So be very, very mindful of that. Then they go on to specifically talk about some of the provisions within the employee handbook. Now, might be different names. The employee handbook, the employee manual, policies and procedures manual, they're all pretty much for the same purpose, right? And then again, they give us a case on page 278 to 280 that talks about this. It'll give you an example of this. This is really, the employee handbook is really part of the employment contract. Okay, so be careful how it's used. HR people should know how to do this. The job security provisions in the employee handbook are enforceable. So remember that, right? Because these are bilateral contracts, an agreement between two, right? And this is partly why we need to train our supervisors and our managers, our leaders at all levels, because they need to understand why these things are important and why we enforce them in a certain way. You can read more about the handbook as we go forward here. On page 268, protecting your right to fire. Again, it makes it feel like, oh, we can't ever do anything right. No, you can protect your right to fire, but do it. All you really have to do is, if you are fair and conscientious about what you do in the workplace and how you dismiss someone, you are fine. Don't think that I'm one of those people. If you have wore out all of the steps within the disciplinary model, the disciplinary process that whatever company you're working for uses, and we've tried training and coaching and all of those things, fire them. They're not on the right seat on the bus, right? The book, Good to Great, Jim Collins. Gosh, sometimes I get my name of the book and the authors mixed up. Talks about the school bus, right? The school bus is the organization, and we hire someone to sit in every seat on the school bus, right? Well, if you're not working well in the seat that you're in, your employer should do everything they can to try in another seat. But you know what? After we've tried every darn seat on the bus and you're still not working out, I mean, no, Jim Collins doesn't say this, if that's the right author, but Rock says this. Open that little door in the back, boot them out, fire them. They're not a good fit for whatever it is that you're doing. But you are going to what? Document, 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 right? You're going to follow policies and procedures, right? So that is what we call a good fire, right? So if you look at those three things on page 268, if the employer publishes a handbook, the at-will policy is preserved if the book includes special language, blah, 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 right? The at-will policy is further protected if the employer states that published reasons for the discharge are merely illustrations. They're not exclusive. And if they receive the handbook, employees are required to sign an acknowledgement that they've received it. So if you just do these things, you'll be fine. Publishing disclaimers, you can read that. And then it goes on to the cases. So read through the cases. They're really interesting. Some of them actually even come out of Wisconsin. And that really takes us, that's it. Wow, I'm at the end of the chapter already. So that was chapters 3 and 13, and then those extra pages introducing us to that section 3, starting on page 255. I'm getting wore out here. I'm doing all these videos and like a marathon. It's my video marathon day. All right, we'll see you later.